Hi, this is Chapter 22, Ethics and Values. Ethics is the study of what is right and wrong with our conduct. It concerns our obligations to individuals, groups, and society. Acts that are ethical reflect the commitment to standards that individuals, professions, and society strive to meet. When decisions must be made about health care, understandable disagreement can occur among healthcare professionals, families, patients, friends, and people in the community. The right thing to do can be difficult to determine, particularly when individual values, beliefs, and perceptions conflict. This chapter describes concepts that will help you embrace the role of ethics in your professional life and promote resolution when ethical problems develop. Use your critical thinking and clinical judgment skills and ethical decision making when working through ethical problems with patients and families. Okay, basic terms in healthcare ethics. Morals. Morals usually refer to judgment about behavior based on specific beliefs, and ethics refers to the study of the ideas of right and wrong behavior. A value is a deeply held personal belief about the worth a person holds for an idea, a custom, or an object. The values that a person holds reflect cultural and social influences. The study of bioethics represents a branch of ethics within the field of healthcare. The study of bioethics has grown over the last 50 years, beginning with the emergence of technologies related to organ transplant. Autonomy. It refers to freedom from external control. In healthcare, the concept applies to respect for the autonomy of patients. It can also apply to agency respect for the autonomy of healthcare professionals. A commitment to respect the autonomy of others is a fundamental principle of ethical practice. Beneficence refers to taking positive actions to help others. The concept of beneficence is fundamental to the practice of nursing and medicine. This agreement to act with beneficence implies that the best interests of the patient remain more important than self interest. It implies that nurses practice primarily as a service to others, even in the details of daily work. Non malfeasance. Non malfeasance refers to harm or hurt. Non malfeasance refers to the avoidance of harm or hurt in healthcare. Ethical practices involves not only the will to do good, but the equal commitment to do no harm. Justice refers to fairness and the distribution of resources. The term is most often used in discussion about access to health care, including the just distribution of scarce services and resources. Discussions about health insurance, hospital locations, and services, and organ transplants generally are among the issues that cite the concept of justice. The term itself is open to interpretation, as people interpret fairness a little differently. Just culture. Just culture refers to of the promotion of open discussion without fear of recrimination. Whenever mistakes, especially those involving adverse events, occur or nearly occur, blame is withheld at least at first so that system issues and other elements can be investigated for their contributions to the error. By fostering open discussion about errors, Members of the healthcare team become more richly informed participants able to design new systems that prevent harm. Fidelity. Fidelity refers to the faithfulness or the agreement to keep promises. As a nurse, you have a duty to be faithful to the patients you care for, to the healthcare agency you work for, and to yourself. If you assess a patient for pain and offer a plan to manage the pain, the standard of fidelity encourages you to initiate the interventions in the plan as soon as possible and to monitor the patient's response to the nursing interventions. Professional Nursing Code of Ethics. Code of Ethics. Code of Ethics is a set of guiding principles that all members of a profession accept. It is a collective statement about the group's expectations and standards of behaviors. The American Nurses Association established its first code of ethics for nursing in 1950, and the organization has continued to review and revise it periodically. The provisions of the Code of Ethics describe the nurse's obligation to the patient, the role of the nurse as a member of the health care team, and the duties of the nurse to the profession and to society. A few of the key principles in the code include advocacy, responsibility, accountability, and confidentiality. Advocacy refers to the application of one's skills and knowledge for the benefit of another person. Lawyers are sometimes called advocates because they use their expertise to advance their clients' best interests. As a nurse, you advocate for the health, safety, and rights of patients, including their right to privacy and their right to refuse treatment. The word responsibility refers to a willingness to respect one's professional obligations and to follow through. As a nurse, you are responsible for your actions, the care you provide, and the tasks that you delegate to others. This responsibility also means maintaining your competence to provide care and seeking guidance when you are uncertain of your skills and knowledge. You also demonstrate responsibility by applying your workplace place policies and procedures to the care you provide. Accountability. Accountability refers to answering for your own actions. You ensure that your professional actions are explainable to your patients and your employer. Healthcare agencies also exercise accountability by monitoring individual and agency compliance with national standards established by agencies such as the Joint Commission um, is, which the Joint Commission establishes national patient safety guidelines to ensure patient and workplace safety through consistent, effective nursing practices. The ANA promotes ethical decision making by setting standards for the collaborative interprofessional communication. Confidentiality refers to the healthcare team's obligation to respect patient privacy. Confidentiality is a fundamental part of the trusting relationship between a nurse and a patient. Federal legislation known as the Health Insurance Portability and Accountability Act of 1996, which is known as HIPAA, mandates confidentiality and protection of patients' personal health information. The legislation defines the rights and privileges of patients for protection of privacy. It establishes fines for violations. In practice, you cannot share information about a patient's medical condition or pertinent information with anyone who is not involved in the care of that patient. HIPAA calls for this right to know. HIPAA also regulates communication of a patient information contained in or within that particular person's medical records as well. Values. 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 Nursing is somewhat is a work of intimacy, right? So nursing practice requires you to be in contact with patients physically, emotionally, psychologically, and spiritually. In most other intimate relationships, you should choose to enter the relationship anticipating that at least some of your values will align with those of the other person. But as a nurse, you agree to provide care to your patients solely on the basis of their need for your services. The ethical concepts of beneficence and fidelity shape the practice of healthcare and distinguish it from other common human relationships such as friendship, marriage, and employer employee. But its very nature, relationships in healthcare sometimes occur in the presence of conflicting values. A value is a deeply held belief about the worth of an idea, attitude, custom, or object that affects choices and behaviors. While values reflect cultural and social influences, they can change over time as individuals become part of different groups. For example, you have personal values from your family, education, and other experiences, and then as a nurse, you develop professional values as a member of the nursing profession and the healthcare team. Recognizing your own values is like seeing the bubble you live in. Most of the time, we look at the world through the lens of our values without acknowledging them. Values are intrinsic to our view of the world. Learning to appreciate your values as your own individual perspective is the first step to working effectively with other healthcare professionals, patients, and families whose values are different. Values clarification. Ethical dilemmas almost always occur in the presence of conflicting values. To resolve ethical conflicts, one needs to distinguish among value, fact, and opinion. Facts are supported by objective data, and opinions are views or ideas that are not necessarily based on facts. Sometimes people have such strong values that they consider them to be facts. However, when people express a strong emotional reaction, this is often a sign that their values are threatened. Sometimes people are so passionate about their values that they become judgmental in a way that intensifies conflict. Clarifying values, your own, your patients, your coworkers, is an important and effective part of ethical discourse. Examine the cultural values exercise in box 22.1. The values in the exercise are in neutral terms so that you can appreciate how differing values need not indicate right or wrong. For example, for some people, it is important to remain silent and stoic in the presence of great pain. And for others, it is important to talk about it, to understand and control it. Identifying values as something separate from facts can help you understand others even when there are differences that set you apart. So make sure that you look into examining the culture values exercise and work that in box 22 point one in your textbook as part of an exercise for this chapter. Approaches to ethics. There are different approaches to ethics. Historically, healthcare ethics constituted a search for fixed standards that would determine correct actions over time. Ethics has grown into a field of a study that is more flexible and is filled with differences of opinion and deeply meaningful efforts to understand human interaction. The following review introduces you to some of the philosophical approaches to ethics that you may encounter during ethical discussions or healthcare settings um, in healthcare settings. I'm sorry. These approaches can be intentionally adopted to help you interpret and address ethical problems in practice. To illustrate how these approaches work, consider a situation in which a nurse is caring for an older adult, Stella, who has dementia and who has a son, David, does not adhere to the unit's visitation policy, namely that he leave her beside bedside for half an hour during change of shift. That's basically what David is not doing. So he's supposed to leave her bedside for half an hour during change of shift. Okay, so you got deontology. Deontology proposes a system of ethics that is perhaps most familiar to healthcare practitioners. Deontology defines actions as right or wrong based on their adherence to rules and principles such as fidelity to promises, truthfulness, and justice. Instead of looking at consequences of actions, to determine whether they are right or wrong. Deontology examines a situation for the existence of essential right or wrong. In the situation of Stella and David, the nurse applying a deontology approach may see the right action as seeking help in enforcing the visitation policy. Her fidelity to the healthcare agency supports a duty to enforce its regulations, making an exception for David with when other family members are following the rules is considered an injustice. Deontology requires a mutual understanding of justice, autonomy, and goodness, but it still leaves room for confusion to surface. The principle of respect for autonomy can be complicated when dealing with children and patients like Stella, who may be unable to voice their preferences. If Stella stated clearly that she desired David's presence at all times, a respect for her autonomy could be the guiding principle. In this case, the nurse should advocate for an exception to the visitation policy. A commitment to respect the rightness of autonomy is a guiding principle in deontology, but adherence to the principle alone does not always provide clear answers for complicated situations. Next, utilitarianism. A utilitarianism system of ethics proposes that the value of something is determined by its usefulness. The philosophy is sometimes called consequentialism because its main emphasis is on the outcome or consequence of an action. The great good for the greatest number of people is the guiding principle for determining right action in a utilitarian system. As with deontology, utilitarianism relies on the application of a certain principle, measures of good and greatest. The difference between utilitarianism and deontology is the focus on outcomes. Utilitarianism measures the effect that an act will have. Deontology looks at the act itself and judges its rightness, but the rules or principles it upholds. In the case of Stella and David, a nurse applying a utilitarian approach may determine that resolving the issue about David visit should be done in a manner that creates the least risk of disturbing the rest of the patients and the other staff members on the unit. The nurse interprets the greatest good for the greatest number as the absence of conflict and thus negotiates an exception to the visitation policy. While violating the policy is unacceptable in a deontological approach because of the action itself is not good. And utilitarianism, if the outcome, a peaceful interaction with the son, is good, the action itself is considered correct. As with deontology, the utilitarian approach has some flaws, mainly that it can be taken too far. Do the ends always justify the means? A classic example in healthcare is the idea of removing organs from a perfectly healthy person to save the lives of seven other people who are awaiting transplantation. Seven people or more than one. So the outcome is good. But does that make the action of killing that one person right? In addition, people have conflicting definitions of greatest good. As with deontology, utilitarianism provides guidance, but it does not guarantee agreement. Casuistry. Casuistry, or case-based reasoning, turns away from conventional principles of ethics as a way to determine best actions and focuses instead on the details of a situation. People who take this approach to ethics find similar precedent cases and they determine a course of action on the basis of what was done to manage that prior situation. As a nurse, applying this approach to the case of Stella and David would consider past instances in which families were permitted to stay at the bedside, even during change of shift, or other instances in which families made a similar request but were asked to follow the policy as it stands. A key step in applying this approach is comparing the details of Stella and David's situation, such as her prognosis and his ability to contribute to her care, to determine which prior situation is the closest match. A weakness of the casuistry approach is that finding a similar precedent case may be challenging, particularly in complex situations with unique features. Feminist ethics, noting the limitations of deontology and utilitarianism, scholars were focused on differences between men and women, especially women's point of view, developed a critique of conventional ethical philosophies called feminist ethics. This view holds that the natural caring for others is the basis for moral behavior. It places an emphasis on caring relationships and a strong sense of responsibility. Those with a feminist perspective tend to concentrate more on practical solutions than on theory and to ask questions about the people involved in their relationships rather than looking to underlying principles. For Stella and David, a nurse taking the feminist approach might look for a power imbalance and seek to take action that addresses it. Is David's presence at the bedside intimidating for Stella? Or staff members seeking to enforce the policy, assuming a position of unjustified power over David? These questions, which may not surface in a traditional approach, will help determine the action that is right for a feminist ethics perspective. Critics of feminist ethics worry about the lack of appeal to traditional ethical principles. Without guidance from concepts such as autonomy and beneficence, they argue solutions to ethical questions will depend too much on subjective judgment. Ethics of care, an alternative view to utilitarianism and deontology, similar to feminist ethics, care based ethics focuses on understanding relationships, personal narratives, and the context in which ethical problems arise. Unlike feminist ethics, ethics of care emphasizes the role of the decision maker in the situation. With deontology and utilitarianism, the decision maker is detached and objective. Gathering facts, identifying principles, or predicting outcomes. In the ethics of care, nurses participate in clinical ethics consultation, with patient advocacy being a top priority. This philosophy often resonates with nurses who, in their intimate experiences with patients, are often making ethical decisions while engaging in a caring relationship. A nurse in taking the ethics of care approach with Stella and David first learns more about the relationship involved in the current situation and then identifies the course of action that best supports them. Stella and David have a relationship with each other, and the nurses caring for Stella also have a relationship with each of them. What action allowing David to stay or asking that he leave will have the best impact on those relationships? Are there additional actions, such as listening to David's reasons for wanting to stay, that may have a positive impact on that particular relationship? Types of ethical problems. Types of ethical problems. Two common ethical problems that nurses encounter are ethical dilemmas and moral distress. As an example, take a situation in which a nursing student working with an older adult finds that the patient refuses to take her morning pill. I won't take a single one until you give me my hormone medicine. The patient has several medical problems, but none of her morning pills fit the description of hormone medicine. In relating the issue to another member of the healthcare team, she is advised, why don't you go in there with one of the pills she needs and tell her it is her hormone pill? Then she'll cooperate with you. The nursing student has an ethical dilemma. Okay. The nursing student immediately feels conflicted by this advice. If the student follows the suggestion, the student can accomplish the task of administering the medications, a task that is in the patient's best interest and so could be justified by the principle of beneficence. At the same time, the student feels uncomfortable lying to the patient. Lying to her is a violation of the patient's autonomy, a betrayal of her trust. This interpretation of the situation is the classic example of an ethical dilemma. The student cannot do both options: take the advice to lie so that the patient gets the benefit of the medication, and be truthful in identifying the pills to the patient. An ethical problem is called a dilemma when two opposing courses of action can both be justified by ethical principles. Moral distress. Now imagine the same situation with a change in details. The person the nurse and student consult for help is the patient's health care provider, and the advice to lie about the pills feels to the student like a specific direction, not so much a suggestion, but more of an order. At the same time, envision that at this moment during the clinical day, there's no one else the student can turn to for help. The student was told by her clinical instructor about the need to be more efficient in completing tasks, and the medications were due to be given 30 minutes ago. Given the pressure of time and the source of the advice, the student might feel compelled to lie to the patient. But what if, based on her values, the student feels that action is morally wrong? Now the student is at risk for moral distress. A different ethical problem. In moral distress, instead of competing options for action, the nurse feels the need to take a specific action while believing the action to be wrong. Distinguishing between ethical dilemmas and moral distress is important to achieving resolution. When the problem is a dilemma with two opposing but justifiable options, often the application of the nursing process will include identifying more options. For example, the student might be able to succeed in giving the patient her medications without lying if the student builds trust with the patient by spending time with her. With moral distress, as the example shows, the environment often contributes to the problem. Discuss situations that generate moral distress with another person when they are identified. Additional resources such as nursing colleagues, managers, and other healthcare professionals can work together to address the factors that contribute to moral distress. Ethics committees. Most hospitals have an ethics committee devoted to the teaching and processing of ethical issues and dilemmas. An ethical committee involves individuals from different disciplines and backgrounds who support healthcare agencies with three major functions: providing clinical ethics consultations, developing and or revising policies pertaining to clinical ethics and hospital policy, directives, withholding and withdrawing life sustaining treatments, informed consent and organ procurement, and facilitating education about topical issues and clinical ethics. In most agencies, any person seeking ethical advice, including nurses, physicians, healthcare providers, patients, and family members, can request access to an ethics committee. Ethic committees often conduct their work by calling a meeting with the members of the team and the patient and family involved in the situation. When you attend an ethics meeting, be sure to articulate a personal point of view and at the same time show respect for that point of view of others. A successful meeting is one in which every perspective is heard. Sometimes these meetings result in consensus around a specific course of actions. Other times the meeting ends with a clear plan, but with an improved understanding of one another's perspectives. You may also process ethical issues in settings other than a committee. Nurses provide insight about ethical problems at family conferences, staff meetings, or even in one to one meetings. As a member of a healthcare community, regardless of your work setting, you can reduce the risk for moral distress by promoting discourse even when disagreements or confusions are profound. You will find it helpful when engaged in these conversations to assume that all the participants want to do good, even if they may have a different idea about what that absolutely means. Processing an ethical problem, nursing point of view. Okay, first there's several steps, which includes a level of up to seven. You're expected to know these steps. Step one, you ask, is this an ethical problem? Step two, you gather information relevant to the case. Patient, family, healthcare agency, and social perspectives of important sources of relevant information. Step three, identify the ethical elements in the situation by clarifying values and recognizing the principles involved. Distinguish, distinguish among fact, opinion, and values. Step four, name the problem. A clear, simple statement of the problem is not always easy, but it helps to ensure effectiveness in the final plan and facilitates discussion. Step five, identify possible courses of action, access others for their input, and be creative in identifying different opinions. Step six, create and implement an action plan. Gather support from others, and identify an alternative action if the chosen one does not achieve resolution. Step seven, evaluate the action plan to determine whether further action is needed or if lessons learned, and this experience can be applied forward. Issues in healthcare ethics. Issues in healthcare ethics. Ethical issues change as society and technologies change, but common denominators remain. The basic process used to address the issues and your responsibility to deal with them. The following section describes a few of many current sources of ethical concerns. Social media. The access to the internet based social networks such as Facebook, Twitter, Snapchat, YouTube, and Instagram may present ethical challenges for nurses. On the one hand, social media can be a supportive source of information about patient care or professional nursing activities and can provide you with emotional support when you encounter hardships at work. Social media can also be a source of support to your patients to connect with friends and loved ones who cannot be physically present. On the other hand, the risk to patient privacy with social media is great. Posting information or pictures about patients, even without specific identifiers, is a violation of confidentiality. Interaction between healthcare professionals and patients on social media is also problematic. Online friendship with a patient risks clouding your ability to remain objective in your clinical perceptions. This crosses the professional boundary between the patient and professional, and the relationship becomes more personal. The public nature of online interactions poses the additional risk that other users will recognize the nature of your relationship with the patient and learn more than they should about the person's health. Workplace policies may help to answer questions you have about when and where it is appropriate to engage in social media. In addition, the ANA has created a web page with principles to guide nurses' use of social media. See https colon www.nursingworld.org slash social slash that's it. Quality of life. Quality of life is deeply personal. Healthcare researchers use quality of life measures to scientifically define the value and the benefits of medical interventions. Any intervention creates a burden for the patient and family, and this must be offset by the benefit that the will that they will receive from that care. For instance, injections of flu vaccine, for instance, cause pain, but the short term nature of this burden is offset by the large benefit of potentially avoiding infection with the flu or spreading of the flu, which are low quality experiences. A more complex intervention, such as a 6 month course of chemotherapy, creates a greater burden and so impacts the quality of the patient's life to a greater degree. That impact is acceptable if the treatment outcome is a return to quality of life based on the patient's definition. In the event that the treatment is unlikely to result in a quality of life that the patient finds acceptable, a different plan of care is considered. Objective measures of quality of life can include the age of a patient, the patient's ability to live independently, or the ability to contribute to society in a gainful way. Subjective measures involve asking patients to identify their priorities, what they enjoy, and what matters most to them. Increasingly, scientists incorporate not just observed measurement, but also patient self reports about quality of life and other outcomes referred to as patient reported outcomes. As a nurse, you can facilitate conversations about treatment choices by encouraging patients to articulate their definitions of quality of life. Care at the end of life. Providing care to patients at the end of life and to those with serious illnesses who may be nearing end of life is a frequent source of ethical dilemma or problems. I'm sorry. While everyone can agree that a good death is desirable, there are a variety of opinions about what a good death looks like. In addition, patients and families may have goals for end of life, such as adequate pain control or being with family, but expect that this will happen much later and not now. Predictions about health outcomes are not always accurate. Thus, healthcare providers may have um, difficulty conveying to patients with serious illnesses that end of life is at hand. Because views about death and dying are part of deeply held spiritual and cultural beliefs, conflicts about end of life care are common in healthcare. These conflicts can occur between members of the healthcare team and among patients, families, and team members. The team futile refers to something that is hopeless or serves no useful purpose. In healthcare discussions, the term futile refers to interventions unlikely to produce benefit for a patient. For example, if a patient is dying of a condition with little or no hope of recovery, almost any intervention beyond symptom management and comfort measures is seen as futile. In this situation, agreement to label an intervention as futile can help the healthcare team members, families, and patients turn to palliative care measures as a more constructive approach to the situation. Access to healthcare. Access to healthcare is an ethical issue of justice. The question of is healthcare a right that everyone can claim, and how can we best divide the healthcare resources we have, involve fairness and justice in the United States. The cost of care is such that few can afford services unless they are enrolled in an insurance plan. In some cases, health insurance is provided as a benefit of employment. Those who do not have employer-based health insurance may qualify for state-based Medicaid programs on the basis of need or for Medicare, a federal insurance program available to all individuals aged 65 and older. Because of conflicting views about what is fair and because of its effect on everyone, access to health care is a controversial issue. While the nature of insurance coverage varies, most plans allow an individual to access some basic preventive care and more expensive urgent services when unexpected changes in health occur. In the latter part of the 20th century, as healthcare costs increased at a dramatic rate, the number of people who insurance declined in 2010. The Affordable Care Act was passed to create regulations that control costs and improve the availability of insurance. This legislation has facilitated access to care for millions of formerly uninsured individuals in the United States. According to a 2019 report by the National Health Center for Health Statistics, part of the U.S. Department of Health and Human Services, the number of uninsured people in the United States declined by 18 million between 2010 and 2018. The ACA also offered changes in payment for services to reward practices that reduce harm and promote quality outcomes. The aim of this part of the legislation was to expand access to less expensive preventive health services and so to reduce the incidence of expensive, burdensome chronic illness. How people access health care in the United States will continue to evolve. Staying knowledgeable about affordable care in your community as a way to ensure healthy outcomes is an important part of your role as advocate for your patients and reflect your ethical commitment to justice. Okay, so next we're going to go to chapter 23. That was the end of your ethics, chapter 20 through 20, 22. And next, the next one will be your chapter 23, which is the legal. So I'm going to give everybody a chance to take a quick little 5 minute break, and then you can stop it, the recording, and then we can go to legal implications in nursing. Chapter 23, Legal Implications in Nursing Practice. Safe, evidence-based, and competent nursing practice requires nurses to know laws, regulations, and policies that help to frame the healthcare system and nursing practice. They include state nurse practice acts, the scope and standards of nursing care, and the code of ethics for nursing practice. Understanding where you fit in the healthcare system demands clinical judgment skills. Society expects safe healthcare delivery, especially from nurses who typically are perceived as being part of the most ethical and trusted professions. As patient care becomes more complex and practice innovations and new healthcare technologies emerge, the principles of negligence and malpractice liability are being applied to challenging new situations. Therefore, you need to know laws governing nursing practice to provide evidence based care that keeps the patient at the center of the decision of nursing. Legal limits of nursing. Sources of law. Many types of law govern nursing practice, including constitutional law, statutory law, common law, administrative law, and case law. Knowing these sources of law informs your practice and identifies why it is important to provide current evidence based care when working with your patients. Constitutional law is derived from federal and state constitutions. For example, in the United States, a constitutional right afforded to every citizen is the right to refuse treatment. As a nurse, you must understand the rights of your patients to refuse treatment even when you may not agree with their decision. Statutory law. Statutory law is derived from statutes passed by the U.S. Congress and state legislatures. These laws are either civil or criminal. Civil laws protect the rights of individuals and provide for fair and equitable treatment when civil wrongs or violations occur. Nurse Practice Acts are civil state laws that define nursing and the standards nurses must meet within individual states. Your state's Nurse Practice Acts defines a nurse's scope of practice, the educational requirements you may have to be a nurse, and how to obtain licensure as a nurse in your state. Nurse Practice Acts also distinguish nursing from other health professions, medicine therapists, and any alternative medicine providers. Criminal laws protect society and provide punishment for crimes, which are defined by municipal, state, and federal legislation. Typically, actions that violate criminal laws are defined as either misdemeanors or felonies. Criminal mistreatment of adults who are vulnerable is an example of criminal statutory law. Criminal mistreatment is classified as either a misdemeanor or a felony offense, depending on the severity of harm done to a patient who is vulnerable. Oh, let me go back. So, administrative law or regulatory law more clearly defines expectations of civil and criminal laws. For example, a Nurse Practice Act as a civil statutory law. That duty means you will observe, assess, diagnose, plan, intervene, and evaluate patient care. Providing current evidence-based care is essential to meeting nursing statutory duty and regulations. Regulatory law also describes the process to report incompetent or unethical um, nursing care. A nurse who does not report unethical or incompetent conduct violates regulatory law. Nurses can appeal violations to the State Board of Nursing Commission. In comparison, criminal mistreatment statutes have regulations to determine the intent of the person who commits the crime. The degree of offense often distinguishes whether the person intentionally committed the mistreatment, knew or should have known harm would result, or did not consider that harm would result. Nurses who are accused of violating a regulatory typically knew or should have known that their actions could result in patient harm. Common law originates from decisions that were made in the absence of law. For example, the right to privacy is implied in the U.S. Constitution. Thus, patient confidentiality originated as common law. Prior to the passage of multiple related laws, a patient's right to confidentiality, which prevents nurses and healthcare providers from sharing patient information with others who are not caring for the patient, was implied through common law. Case law describes decisions made in legal cases that were that resolved in courts after a case is presented to a judge or jury. There's a report of the issue, facts, findings, and subsequent decisions that were made to resolve the issue. For example, in Jefferson versus Mercy Hospital and Medical Center, the guardian of the estate of Miss Turner alleged that her health care providers did not meet the standard of practice when caring for a tracheostomy required to assist her to breathe. Subsequently, she died. A trial, the jury concurred and awarded the estate 22 million. After an appeal and a lengthy analysis, the court awarded in favor of the estate for 7 million in light of the past damages, but it denied the request for future damages in the amount of uh, 15 million. Legal limits of nursing. Scope and standards of nursing. The scope and standard of nursing practice defines nursing and reflects the values of the nursing profession. Standards of nursing care reflect the knowledge and skill ordinarily possessed and used by nurses to perform within the scope of practice. Standards of nursing care are derived from healthcare laws, best practice guidelines, white papers written by professional organizations, evidence based nursing knowledge, and citizen advocacy groups. The ANA and specialty nursing organizations develop standards for nursing practice. The Code of Ethics for Nurses and policy statements. For example, the scope of nursing and 17 standards of practice that describe what nurses do are published by the ANA. Nursing is defined, and the responsibilities and expectations of a registered nurse are clearly examined. They define the scope, function, and role of nurses in practice and guide your practice. Sometimes they are used as standards when legal actions are taken against nurses. Nursing policies and procedures within healthcare agencies are based on the scope and standards of nursing practice. They must reflect current best practices and the evidence that supports the process for the procedures and policies that they describe. The Joint Commission requires written nursing policies and procedures that are accessible on all nursing units. Agency policies and procedures must conform to state and federal laws and community standards. For example, bedside report is a best practice for healthcare settings because it places patients at the center of decision making and emphasizes the importance of clear communication with patients and their families and the healthcare team. When a hospital establishes a policy and procedure to implement bedside handoff reporting, the nurse who is transferring care of a patient to another nurse, the nurse accepting the care of the patient, and the patient should be involved in the reporting process. If the nurses decide not to follow the policy and procedure, thus the nurses may be at risk for litigation, especially if harm occurs to the patient because of not following the hospital's policy. Thus, it is important to know the scope and standards of nursing practice as well as the healthcare agency's policies and procedures intended to implement them. Patient Protection and the Affordable Care Act. The Patient Protection and Affordable Care Act was passed in 2010. Its name was later changed to the Affordable Care Act, which is ACA or ACA. ACA. The ACA is characterized by four themes: consumer rights and protections, affordable health care coverage, increased access to care, and quality of care that meets the needs of patients. The ACA has been challenged in court many times since its enactment. Examples of issues discussed in court around the ACA, include mandatory enrollment in health care insurance and eligibility for insurance for patients with a pre-existing condition. A new patient's Bill of Rights created by ACA prohibits patients from being denied healthcare coverage based on prior existing conditions, limits on the amount of care for these conditions, and or accidental mistake in paperwork when a patient gets sick. The ACA intended to reduce overall medical care costs, provided providing tax credit, increasing insurance company accountability for premiums and rate increases, and increasing the number of choices available to patients to select insurances the best meet uh, that best meet their needs. In addition, the ACA increased access to health care. Patients now receive recommended preventive services such as screenings for cancer, blood pressure, and diabetes without having to pay copays or deductibles. The ACA improved Medicare coverage for vulnerable populations by proving access to care and prescriptions, decreasing costs of medication, extending the life of Medicare Trust Fund until 2024, and addressing fraud and abuse in billing practice, which is really ridiculous. The ACA reduced the number of uninsured Americans from over 44 million people in 2013, right before the Act's healthcare covered provisions began, to just below 27 million people in 2016. However, starting in 2017, the number of uninsured people started to increase again, with 28.9 million non-elderly individuals being uninsured in 2019. The, the number of uninsured people remains substantially lower compared with 2010. The high cost of medical insurance and not having access to medical coverage through an employer are the main reasons people remain uninsured. Other adults are ineligible for financial assistance for healthcare coverage, especially those who live in states that did not expand Medicaid coverage, which Florida, I'm pretty sure, since DeSantis had took over, was one of those. Those who remain uninsured typically are in families that have at least one family member who works, or in families that have a low income, especially below 200% of the federal poverty level and or adults under 65 years of age. People of color have a higher risk of being uninsured when compared with non-Hispanic white people. The ACA is politically charged and frequently debated. Thus, like all statutes, the ACA has the potential to change. For example, the Centers for Medicare and Medicaid Services proposed changes to the ACA to increase the affordability of coverage to allow people to join qualified health plans, which is QHP. That did not cover termination of pregnancy service and to provide greater flexibility in how people shop for QHPs. In 2019, the Fifth Circuit of the U.S. Court of Appeals ruled that requiring all Americans to have health care coverage was unconstitutional. The U.S. Supreme Court upheld the constitutionality of the ACA in spring of 2021. It is especially important that nurses have current factual knowledge voices their opinions to approve legislators about issues that affect healthcare and provide accurate information to patients when they seek guidance about their healthcare. Nurses are often at the center of those decisions with their patients. It is critical that when helping patients make decisions about their care, the decisions are clinically sound and based on the patient's preferences, values, and beliefs. So that is like a big thing. Uh, Emergency Medical Treatment and Active Labor Act. The Emergency Medical Treatment and Active Labor Act EMTALA prohibits, and that was from 1986, prohibits the transfer of patients from private to public hospitals without appropriate screening and stabilization. It is intended to prevent patient dumping. This act ensures that patients are medically screened when they come to the emergency department or the hospital. Staff must assess all patients who enter the hospital and cannot discharge or transfer them until their conditions stabilize. Exceptions to this provision include if a patient requests transfer or discharge in writing after receiving information about the benefits and risks of the transfer, or if a healthcare provider certifies that the benefits of transfer outweigh the risks. Health Insurance Portability and Accountability Act, which is HIPAA, provides rights to the patients and protects employees. It includes standards regarding accountability in the healthcare setting. Notably, it established patient rights regarding privacy of their healthcare information and records. HIPAA established the patient's right to consent to the use and disclosure of protected health information, to inspect and copy one's medical records. That is something that we can do, and to amend mistaken or incomplete information. It limits who can access a patient's record. It establishes the basis for privacy and confidentiality concerns viewed as two basic rights within the U.S. healthcare system. Privacy is the rights of patients to keep personal information from being disclosed. Confidentiality protects private patient information once it is disclosed in healthcare settings. Nurses help healthcare agencies protect patient rights to privacy and confidentiality. Although HIPAA does not require extreme measures such as soundproof rooms in hospitals, it does mean that nurses and healthcare providers need to avoid discussing patients in private public areas like hallways, elevators, cafeterias, and provides reasonable levels of privacy when communicating with and about patients in any manner. Thus, nurses must be especially vigilant to ensure that patients are afforded the privacy they are entitled to, and that is mandated in law. For example, message boards used to post daily patient care information in patient rooms or patient care units cannot contain information revealing a patient's medical condition. Healthcare information privacy is also protected by standards set by CMS for hospitals and healthcare providers who participate in Medicare and Medicaid. These standards require that hospitals and healthcare providers give notice to patients of their rights regarding decisions about their healthcare, grievances regarding their care management, personal freedoms and safety, confidentiality, access to their own medical records, and freedom from physical or chemical restraints that are not clinically necessary. In addition, many state laws allow patients to access their medical records. Exceptions apply to psychotherapy notes or when a healthcare provider has determined that access will result in harm to the patient or another or another party. Health Information Technology Act, the Health Information Technology Act for Economic and Clinical Health Act was passed with HIPAA in response to new technology and social media, especially when a security breach patient health information occurs. Under the Health Information Technology Act, nurses must ensure that patients' personal private health information is uh, uh, protected um, and it's not inadvertently conveyed on social media, and that protected data are not disclosed other than as permitted by patients. Best practices, regardless of patient consent, is to never post patient information on social media, electronic data, or accessible, regardless of assurances to the contrary. Civil and criminal sanctions may be brought against both a nurse and an organization if either or both violate HIPAA or the Health Information Technology Act. Report violations of patient confidentiality to your supervisor as defined by the statute and the U.S. Supreme Court. A disability is a mental or physical condition that substantially limits a major life activity, including seeing, hearing, speaking, walking, breathing, performing manual tasks, learning, caring for oneself, and or working. Employees must provide reasonable accommodations to employees or applicants who are qualified to hold a job. Reasonable accommodations enable a person to perform the essential functions of a job. Consider the case of Brian, a nurse who has a hearing disability and who may require accommodations to work safely. Under the ADA, Brian is not required to report his hearing disability. Rather, he is able to make the choice whether to tell others of his disability. Under the ADA requirements, Brian's employees must consider his needs and must provide reasonable accommodation, such as a special stethoscope that allows for amplification of sounds to allow him to practice nursing safety. The Americans with Disabilities Act, the Americans with Disabilities Acts of 1990 and amended in 2008 is a civil rights statute that protects the rights of people with physical or mental disabilities. The ADA provides discrimination. ADA prohibits discrimination and ensures equal opportunities for people with disabilities in employment, state, and local government services, public accommodation, commercial facilities, and transportation. It is enforced by the Office of Equal Employment Opportunity, although the ADA protects healthcare workers who have disabilities in the workplace. Several cases have held that healthcare providers must disclose if they are uh, human immunodeficiency virus or HIV positive. However, healthcare workers cannot discriminate against patients who are HIV positive. Another is the Mental Health Parity and Addiction Equity Act. The Mental Health Parity and Addiction Equity Act was originally passed in 1996. Amendments were passed in 2008. Then it was amended by the Healthcare and Education Reconciliation Act of 2010, and it eventually became a part of the ACA. Um, the Mental Health Parity and Addiction Equity Act requires health insurance companies to provide coverage for mental health and substance use disorder treatment, just as they do for medical coverage. The ACA extended these requirements to small groups and individual health insurance plans, and the ACA requires parity um, the state or condition of being equal in the provision of 10 specific services, including mental health, behavioral health, and SUD services. Insurance may not discriminate or which is SUD, I'm sorry, is substance abuse, y'all. Substance use um, disorder. Uh, Insurance may not discriminate or deny coverage to patients with mental illness or substance use disorder because of pre-existing conditions. The Mental Health and Substance Use Disorder Parity Task Force facilitates coordination of services among federal agencies and ensures that consumers receive the care and treatment they require. The task force of improved awareness of the benefits that Parity for Mental Health and SUD provide. For example, to increase transparency, the task force has helped stakeholders understand what equality means uh, in uh, relation to treatment of mental health illnesses and substance use disorders. The task force also provides resources to ensure the coverage is consistent with the intent of the Mental Health Parity and Addiction Equality Act, which they call MHPA EA. So patients are admitted either voluntary or involuntary to a mental health or substance use disorder unit. Involuntary admission to a mental health center usually occurs when patients are a danger to themselves, like for instance, if they are suicidal or others. Typically a mental health professional makes this decision in the emergency room. In some states, patients with an substance use disorder can also be placed in a treatment center by a substance use disorder professional if they are a danger to themselves or others. In either case, the professional who assesses the patient, a court-appointed guardian ad litem, a family member, or another interested party can ask the court to determine whether a longer stay is required to protect the patient from continuing to harm self or others. A judge may order the patient to be hospitalized for 21 or more days for treatment. From a legal perspective, this is viewed as taking away a patient's constitutional rights. Nurses must clearly and accurately document the patient's behaviors. The court will review the evidence when making its decisions. Under constitutional law, having the right to move from place to place is at the very basis of being a U.S. citizen. When removing that constitutionality protected right, the case must be made that not doing so would result in significant or deadly harm. When patients attempt suicide within healthcare settings, it is typically alleged that nurses fail to provide appropriate individualized care, supervise the patient adequately, and adhere to existing policies and procedures to keep the patient safe. When providing care to patients with mental illnesses and substance use disorders, consider the regulations associated with their care. You also need to know your agency's policies and procedures when caring for patients at risk of harm. Integrate these knowledge to provide evidence-based nursing and to ensure that your documentation reflects the care you provided. Patient Self-Determination Act. The Patient Self-Determination Act requires healthcare institutions to provide written information to patients concerning their rights to make decisions about their care including the right to refuse treatment and to formulate an advance directive. A patient's record must indicate whether a patient has signed an advance directive and include a copy of the directive uh, if it is available. Patients must also be offered information about advance directives. An advance directive is a document developed by patients that instruct others to do tasks before, during, and after their death. At a minimum, an advance directive includes a statement of a patient's wishes if a respiratory or cardiac arrest occurs, and a copy of the patient's durable power of attorney for health care. Instructions regarding care before or during cardiac or respiratory arrest should be signed by either a physician or a nurse practitioner unless otherwise specified by state law. The document should be treated as an order if it may direct whether to provide life-saving measures such as uh, CPR or to provide comfort care only. Most of durable power of attorneys for health cares begin with a statement that says that the designated person can make decisions when the patient becomes incapacitated. This means that the patient cannot be bypassed. They retain the ability and the rights to make their own decision whenever they can. This is true whether they are at a home, in the emergency room, or in an inpatient setting. Decisional capacity is the patient's ability to make choices about care. The healthcare provider, working in conjunction with information from the nurses and family members, can make the determination of decisional capacity. The power of attorney for healthcare may not be asked and cannot make healthcare decisions until a provider makes an assessment that the patient no longer has the capacity to make decisions. The assessment that triggers the beginning of the durable power of healthcare um, may not be asked and cannot make healthcare decisions and provider makes an assessment for the patient and no longer has the capacity to make decisions. The assessment that triggers the beginning of the DPAHC should be reflected in the medical record. When the physician or nurse practitioner is unable to determine capacity of their, or if there is a disagreement regarding the patient's capacity, a competency hearing is conducted in court on the patient's behalf, uh, as in involuntary commitment hearings. The court is asked to deny a U.S. citizen the constitutional right to make decisions, which essentially takes away all rights and privileges provided as a U.S. citizen. When the patient is determined to be incompetent, a guardian is appointed to make decisions regarding care the patient will or will not receive. No other person, including family members or providers, has the power to override the guardian's decisions. To do so, the person must return to court and explain why the guardian's decision should not be honored. Thus, under um, the the power of attorney and states specific statutes, advance directives that include a DPA, HC, and orders whether or not to provide resuscitation must be clear and in compliance with the law. Nursing care is individualized based on the patient's instructions and on the state in which the patient resides at the time a directive is implemented. The DPAHC's ability to make decisions um, for the patient ends at the time of death. Therefore, it is important that patients and their families arrange their afterlife care in advance. So it can be pretty a big way. Living wills also include information about the patient's preferences regarding end of life care. Some include physician orders about sustaining life, such as use of enteral feedings, Others contain information on whether to initiate CPR on cessation of breathing. It is important to thoroughly read documents titled Living Will. They are based on values of informed consent, patient autonomy. A patient must be capable to make decisions regarding healthcare treatment when creating a living will. Many resources are available to help create a living will. For example, Five Wishes is an organization that helps patients write their directives when responding to five questions. The questions help patients identify uh, uh, a DPA-HC, the kind of medical treatment wanted or not wanted, comfort measures they wish to receive, how they want to be treated by those around them, and what they want those who love them to know. Providing this information and assisting patients in recording their wishes is rewarding for the patient, empowering to their loved ones, and humbling to the nurses who help them. Providing this information and assisting patients in recording their wishes is rewarding for the patient, empowering to their loved ones, and humbling to. Also, I wanted to tell you guys about there was like, when a person writing a living will and that type of thing is very important. For example, courts upheld the patient's right to refuse medical treatment um, in a case. Bovia versus Superior Court in 1986, the courts have also upheld the right of a legally competent patient to refuse medical treatment for religious reasons. Uh, so basically, in 1990, it was a report said Cruzan versus Director of Missouri Department of Health case in 1990, where they said that we assumed that the U.S. Constitution would grant a constitutionally protected competent person the right to refuse life-saving hydration and nutrition. In the Terry Schiavo case, y'all remember that was here in Florida, and that was in 2003. Schiavo's husband, who was her legal guardian, argued that his wife would not want to have her life artificially prolonged. Her parents disagreed and wanted her to continue to receive artificial nutrition and hydration. The court noted that it understood why a parent who had raised and nurtured a child from conception would hold out hope that some level of cognitive function remained. However, after more than 10 years, the court upheld the guardianship court's initial decision to allow Ms. Scheibo's husband as her guardian to make medical decisions on her behalf in the absence of her wishes being known before her death. So it's been like a lot of little cases where it's like preserving medical ethics, preventing suicide, protecting innocent third parties like children, minor children. You depend on the parent. In addition, the patient refusals of treatment the nurses frequently encounter do not resuscitate, which is called DNR or orders, and the state of New York was the first to develop legislation based on the recommendations of the New York State Task Force. These recommendations, which went into effect in 1988, allowed competent adults to authorize a DNR order. So patients' conditions change, and patients have the right to change their minds. The healthcare provider needs to review DNR orders with the patients periodically to ensure that the order reflects current wishes. So they do, and we talked about that previously in the previous chapter about ethics. about there's different protocols. People might just want comfort care. People might not want to be resuscitated. There's a lot of different things, and they'll have a DNR order in their chart, and it has to do with the state that that particular person lives in. You have next the Uniform Anatomical Gift Act, and what that does is it provides the foundation for the national organ donation system. Patient autonomy, individual autonomy, and public trust remain the ethical purposes or ethical principles on which organ donation occurs, and uh, individual autonomy and public trust remain the ethical principles on which organ donation occurs. An individual who is at least 18 years of age and can make an organ donation as a donation of all a part of the human body to take effect upon either death. So you can, a lot of times you'll find that uh, in most states require request laws mandate that at the time of admission to a hospital, a qualified healthcare provider must ask all patients over age 18 whether they are an organ or tissue donor. So individuals are approached in the following order. Y'all probably want to know about this. Uh, the spouse, and then the adult son or daughter, the parent, the adult brother or sister, the grandparent, and then the guardian. So, in that order: spouse, adult son or daughter, parent, adult brother or sister, grandparent, and then guardian. So, y'all make sure that y'all know that as far as like when it comes to a donation and making medical decisions of that kind, that's the order that they do it. And then the ominous budget reconciliation uh, act uh, is significantly altered the way in which healthcare is provided to older adults. It focuses on patient rights, quality of life, quality of care, and the physical environment in which patients live. One change focused on the use of restraints intended to change older adult behavior, address the use of both physical and chemical restraints, and the legal definition of a restraint is a manual method, physical or mechanical device or material or equipment that immobilizes or reduces the ability of a patient to move freely. And with the chemical restraint, the use of medication to alter the behavior of a patient. The use of restraints have been associated with serious complications and even death before, and they set standards. The ANA, the Joint Commission, CMS, all of them set standards to reduce the use of all types of restraints in healthcare settings. All patients have a U.S. constitutional right to be free from seclusion and physical or chemical restraints, except on rare occasions, to ensure the safety of patients, staff, and others in emergency situations. Application of a physical restraint or administration of a chemical restraint must be the intervention of last resort and not the first intervention of choice uh, when a patient is non-adherent, if they are aggressive or combative. Chapter 27 describes interventions for a restraint-free environment and the conditions that ultimately allow restraints to be ordered. You must know current evidence-based and legal procedures related to both the use of restraints and discontinuation. Restraints can only be used uh, to assure the physical safety of the patient or other patients, or when less restrictive interventions are unacceptable, unsuccessful, and only on the written order of a healthcare provider as well. Uh, And when you do have somebody under restraints and seclusion, or in who has been trained in CMS restraints and seclusion requirements, is required to assess the patient face to face within 1 hour or less of applying the restraint. And then I think after that, it's usually every couple hours. Nurse practice laws, practice acts, nurse practice acts, or state laws intended to protect citizens, make nurses accountable, and ensure that care is consistent with best practices within the scope and standards of nursing. Creation uh, of a state board of nursing, sometimes called the Nursing Commission, is part of a state nursing practice act. Members of the board and the board's responsibilities are written in the statutes and in the regulations that more clearly delineate their duties. State boards of nursing educate the public and nurses as the profession changes. For example, uh, uh, white papers to clarify administration of conscious sedation by a nurse have been shared with stakeholders when practice acts are revised or challenged. State boards regulate and disseminate information regarding related information related to nursing care. The State Board of Nursing Commission license RRNs in the state in which the practice they require the licensure uh, to vary among states. The requirements for licenses vary among states. States use the National Counselor Licensure Examination or the NCLEX for nursing examinations. Uh, Legally, a license to practice nursing is considered a privilege, and it is absolutely not a right. So it is a privilege. Licensure permits people to offer special skills to the public, and it also provides legal guidance for protection from the public. The Nurse Licensure Compact enables a nurse enables a nurse states under one license and individual license from each participating state is not required. Having an NLC license allows nurses to provide telehealth care when the nurses work in one state and the patient is in another state. It also facilitates care when nurses cross state lines to provide care during emergency. As practice acts change, more states are participating in the nurse license compact process. And they do offer that here in Florida, and it varies amongst state lines. Um, but it, like for instance, when I told you guys that I had practiced in uh, Arizona, I didn't have to get a Arizona nurse license because I have a compact which allows me to practice in other states in the United States, but the states have to be a state that's participating with the nurse compact. Okay, healthcare acts and informed consent. Healthcare acts within each state describe and define the minimal standards of care that will be provided within their geographical region. These acts and the regulations associated with them are interrelated with other laws governing the practice of nursing, such as expectations regarding informed consent. A patient signed consent form is necessary for admission to a healthcare agency, uh, for central line or insertion surgery, some treatment programs such as chemotherapy, and participation in research studies as well. States' laws designate individuals who are legally able to give consent to have medical treatment. Um, Nurses need to know the laws in their states and be familiar with the policies and procedures of their employing agency regarding consent. Special consideration is used when a patient is deaf, is illiterate, or speaks a foreign language. A professional interpreter must be present or remotely to explain the terms of consent. A family member or acquaintance who speaks a patient's language should not interpret health information. Make every effort to help a patient make an informed choice. In addition, healthcare acts have been amended to include more specific direction to uh, make efforts to explain patient more informed. In addition, healthcare acts have been amended to include more specific direction to ensure that patients receive information that the typical person would reasonably want to know when providing consent to medical care. So that is true. Informed consent is a patient's agreement to have a medical procedure after receiving full disclosure of risks, benefits, alternatives, and consequences of refusal. Informed consent requires a healthcare provider to disclose information in terms a patient can understand to make an informed choice. Failure to obtain consent in situations other than emergencies can result in a claim of battery. Informed consent is a part of the healthcare provider patient relationship. It must be obtained and witnessed when the patient is not under the influence of medications such as opioids. In most situations, obtaining patients' informed consent does not fall within the nurse's responsibility. The person responsible for performing the procedure is responsible for obtaining the informed consent. So key elements. So that's like uh the nurse cannot really just get the informed consent unless she's the one doing the procedure. Usually in most cases, the physician or whoever that's performing the procedure gets the consent. Like for instance, even the anesthesiologist gets a separate consent, you know. Key elements of informed consent include the following. So, know the key elements. The patient receives an explanation of the procedure. The patient receives the names and qualifications of people performing or assisting in the procedure. The patient receives a description of the serious harm, including death, that may occur as a result of the procedure and anticipated pain and or discomfort. The patient receives an explanation of any alternative therapies to the proposed procedure or treatment at the risk of doing nothing. The patient knows of the right to refuse the procedure or treatment without discontinuing other supportive care, and the patient knows of the right to refuse the procedure or treatment even after the procedure has been begun. So you have what they call different laws, statutes, state statutes affecting nursing. One is the Good Samaritan law, limit liability and offer legal immunity if a nurse helps at the scene of an accident. For example, if you stop at the scene of an automobile accident and give appropriate emergency care, such as applying pressure to stop hemorrhage, you are acting within accepted standards. The only thing that I could tell you about a good Samaritan is I do want you guys to remember that you do have to be performing within your particular scope of care. Okay? Like you can't be a RN and stop and uh, perform a tracheostomy on somebody. You know, that's not within your scope of care. Okay? Uh, Public health laws. Public health laws affect the individuals, populations, and communities. They may be either federal or state statutes. Um, they intended to improve the health of people. Uh, So, for instance, there's different health codes which describe the requirement for reporting communicable diseases, school immunizations, and other conditions intended to promote health and reduce health risk in the community. So you can look at the Centers of Disease Control and Prevention in order to in the CDC.gov to look. And then nurses, they have a legal duty to provide care to protect public health. These laws include reporting suspected abuse and neglect of a child, older adult, or victim of domestic violence, reporting communicable diseases, ensuring that the patient and the community have received recommended immunizations, and reporting other health related issues to protect public health. So it's really important that you do that. It may also be a one time act that is a clear and present danger to another's health, wealth, or safety. Neglect does not usually require that a nurse intentionally acts to harm a patient. Rather, the nurse knew or should have known the neglect would occur under the circumstance. Abuse means the willful act of inaction uh, that inflicts injury. So abuse is when you willfully. So you got to know the so notes in situations of neglect or abuse, the standard of proof to report is that a nurse has a reasonable suspicion that the person may be at risk or in at home. So if you have a reasonable suspicion, you should report. Okay. Termination of pregnancy, of course, everybody knows about the case of Roe versus Wade, 1973. The U.S. Supreme Court ruled that there is a fundamental right to privacy, which includes a woman's decision to terminate a pregnancy. The court ruled that during the first trimester, a woman could end her pregnancy without state regulation because the risk of natural mortality from abortion is less than with normal childbirth. Now, during the second trimester, the state has an interest in protecting maternal health and it enforces regulations. But there has been an overturn of Roe versus Wade just recently, and what I need y'all to realize is that a lot of it has been put into the state's hands. In Webster versus Reproductive Health Services in 1989, the court substantially narrowed Roe versus Wade. Some states require viability tests before conducting abortions. Other states require a minor's parental consent or a judicial decision that the minor is mature and can self consent. So just know that there's a lot of laws and different stuff like that in cases where you have to keep in mind that people um, do a lot, you know. Uh, Physician assisted suicide, providing end of life care in today's world is challenging for healthcare professionals because people are living longer. The Oregon Death with Dignity Act in 1994 was the first statute that legislatively defined death with dignity, sometimes called physician assisted suicide. The statute stated that competent individuals with a terminal disease could make an oral and written request for medication to end their life in a humane and dignified manner. A terminal disease is defined as an incurable and irreversible disease that has been medically confirmed and will, within reasonable medical judgment, produce death within 6 months. The ANA believes that nurses' participation in assisted suicide violates the code of ethics for nurses. The American Association of College of Nurses has historically supported the International Council of Nurses mandate to ensure an individual's peaceful end of life. The position of these two national organizations are not considered contradictory and requires nurses to approach a patient's end of life with openness to listening to a patient's expression of fear and to attempt to control a patient's pain during the last months of life. You need to know your state's laws and ensure that your practice falls within laws requirement. The Uniform Determination of Death Act, many legal issues surround the event of death, including a basic definition of the actual point at which a person is legally dead. The definitions vary by state law. There are two standards for the determination of death. The cardiopulmonary standard requires irreversible cessation of circulatory and respiratory functions. The whole brain standard requires irreversible cessation of all functions of the entire brain, including the brainstem. Most states have statutes like the proposed language in the Uniform Determination of Death Act. It states that the healthcare providers can use either the cardiopulmonary or the whole brain definition to determine death. Be aware of legal definitions of death in your state because you need to document relevant information when the patient is in your care. Nurses have a specific legal obligation to treat the deceased person's remains with dignity. Wrongful handling of a deceased person's remains causes emotional harm to uh, the surviving family. Nursing workforce guidelines, nursing work, nursing workforce guidelines, statutes and agency policies and procedures help to protect healthcare providers and patients, to promote state safety in the workplace and influence your nursing practice, patient assignments and how you delegate nursing care. These laws and policies also provide guidelines for nursing students. You need to be aware of the laws, policies, and procedures that affect your practice and follow them as you plan to care for patients. Adequate staffing and nursing to patient ratios. Adequate staffing is required to patient safety and satisfaction with care. Nurse to patient ratios are determined in different ways. Legal issues occur when there are not enough nurses to provide competent care or when nurses work excessive overtime. In the case of Spires versus Hospital Corporation of America, poor patient care due to insufficient RN staffing resulting in the death of a patient was alleged. This suit emphasized the potential seriousness of short staffing and the importance of nurse asserting employee rights. Some states require the nursing committees and acute care settings to determine safe staff basis on the needs of the patients admitted to their facilities, with staffing committees have worked for determining appropriate staffing needs. Employees uh, have inappropriately asked some committees to make budgetary recommendations to pay for the staffing. In California, fixed nurse patient ratios in acute care settings are mandated by law. The safe staffing ratio debate is occurring throughout the country. Nursing assignments. Nurses are sometimes required to work on a unit where they do not typically care for patients, and this practice often called floating. Nurse temporarily work in another area because there are not enough nurses to care for the number of patients and the acuity of the patient's need on the unit at the time. If you are asked to float, you must inform the supervisor if you do not have the required educational experience to care for the patients assigned to you. You should request and receive an orientation to the unit. Supervisors are responsible to give staff nurses assignments they can handle safely. Before accepting employment, learn the policies of the agency regarding floating and understanding what is expected. Patient abandonment occurs when a nurse refuses to provide care for a patient after having established a patient nurse relationship. Before having established that relationship, a nurse must refuse an assignment when the nurse lacks the knowledge or skill to provide competent care. Care exceeding the Nurse Practice Act is expected. Health of the nurse or the nurse unborn child is directly threatened uh, by that type of assignment. Orientation to the unit has not been completely and safety is at risk. The nurse clearly states and documents a conscientious objection on the basis of moral, ethical, or religious grounds, or the nurse's clinical judgment is impaired as a result of fatigue, resulting in safety risk for the patient. When refusing an assignment, it is important to give your immediate supervisor to specific reasons for the refusal and to determine whether other alternatives such as reassignment are available. Document in your personal notes the specific of the incident, the date and time it occurred, to whom you reported, and actions you took to ensure that patients were safe and that you did not abandon your patient. Nurse delegation a nurse delegation, some state boards of nursing or nurse commissions specifically define responsibilities of the licensed practical nurse RN and advanced practice RNs and develop uh, position statements and guidelines to help RNs and LPNs delegate safety. The process of nurse delegation is defined in Nurse Practice Acts. Regulations vary from state to state. In general, nurse delegation means that an RN educates, observes, and verifies that a non-registered nurse LPN, nurse assistant, or assistant personnel can do a specific task that is usually completed by an RN. Several requirements ensure patient safety when delegating care. The RN retains responsibility to communicate clearly and supervise care received by a patient and to periodically reassess whether nurse delegation continues to be appropriate. Delegated tasks must include hygiene care, ambulation assistance, vital signs, or blood glucose monitoring. RNs can usually delegate administration of medications to LPNs. It is important to know delegation requirements, including caregiver education and experience requirements, and the role and responsibilities of the RN. Just as RNs can delegate to non RNs, LPNs can usually delegate tasks to other members of the healthcare team, such as certified nurse assistants or assistive personnel. Tasks delegated by LPNs often involve basic patient care, helping with ambulation, meeting patients' hygienic needs, and taking vital signs. Nursing students are liable if their actions exceed their scope of practice and cause harm to patients. Regardless of intent, students are expected to know what they can and cannot do when providing care to patients. If a student harms a patient as a direct result of lack of action, the student, instructor, hospital, or healthcare agency, and university or educational institution generally share the liability for the incorrect action. Nursing students should never be assigned to perform tasks for which they are unprepared, and instructors should supervise them carefully as they learn new skills. Although nursing students are not employees of a hospital, the agency has the responsibility to monitor their acts. They are expected to perform as professional nurses would in providing safe patient care. Faculty members are usually responsible for instructing and observing students, but in some situations, staff nurses serve as preceptors, share these responsibilities. Every nursing school should provide clear definitions of preceptor and faculty responsibility. It is equally important that nursing preceptors be aware of state laws applicable to nursing students, faculty, and the educational institution when supervising students. Nursing students should perform only tasks that have been delegated to them and that are included in their title job description when they are employed in healthcare settings as nursing assistants, medication technicians. For example, if a student who also works as a medication technician has learned to administer IM medications in a nursing class, the student cannot administer IM injections when working as a medication technician unless this is allowed under the State Nursing Practice Act and the student's job description. If a staff nurse assigns a nursing student work without regard for the student's ability, to safely conduct the task defined in the job description, the staff nurse is also liable. Nursing students employed in the agency as nurse aides must refuse to perform tasks that are not included in their job description or agency's policies. Nursing students also should refuse to perform tasks that they are not prepared to complete safely. The student employed must tell the supervisor that the task can be assigned to an appropriate healthcare professional. Patient safety is essential. Their actions must meet the standards of practice required for safe care of a patient, whether they are in school, in the community, or uh, uh, employed at a healthcare agency. Err on the side of caution. Do not exceed your scope of practice, whether you are a nurse's aide, nurse assistant, medical assistant, nurse's student, medical technician, or employed with another title. Now let's talk about legal implications and reducing your legal risks. Torts, torts, um, or civil wrongful acts or omissions of care made against a person or property. They are classified as intentional, quasi-intentional, or unintentional. If they're intentional, that means they are deliberate acts against a person or property that may result in both civil and criminal action. No actual contact is required for an assault to occur. For example, if a nurse threatens to give a patient an injection or to restrain a patient while having an x-ray taken when the patient has refused consent, the nurse action is considered an assault. Likewise, assault occurs when a patient threatens a nurse. Battery is an intentional offense, touching without consent or lawful justification. So the contact can be harmful to the patient and cause an injury, or it really can be offensive to the patient's personal dignity. In the example of a nurse threatening to give a patient an injection without the patient's consent, if the nurse gives the injection, it is battery. Battery also results if a healthcare provider performs a procedure that goes beyond the scope of a patient's consent. For example, if a patient gives consent for an appendectomy and the surgeon performs a tonsillectomy, battery has occurred. So the key component is the patient's consent. False imprisonment occurs when the patient is restrained without a legal reason. False imprisonment happens when a nurse restrains a patient in a confined area, preventing the ability to move freely in a bed, chair, room, or the area in which the patient wishes to be. Quasi-intentional torts. Quasi-intentional torts are acts in which a person may not intend to cause harm to another but does. Typically, the person invades another's privacy or in some way defames another's character. Top quasi-intentional torts are alleged when a person should have known the harm to another person could occur. Invasion of privacy is usually the release of a patient's healthcare information. Those go up under that. Defamation of character is the publication of false statements that result in damage to a person's reputation. Slander occurs when one speaks falsely, and libel occurs when one writes something. So if a nurse tells people erroneously that a patient has gonorrhea and the disclosure affects the patient's business, the nurse is liable for slander. Okay, so shortened false defamatory entries in a medical record, for instance, is liable. Unintentional torts arise when a person is harmed and the person inflicting the harm knew or should have known that these actions were less than accepted scope of standard practice. Negligence. Negligence is a conduct that falls below the generally accepted standard of care of a reasonably prudent person. Anyone, including people not in the medical field, can be liable for negligence. Nurses are negligent when they had a duty to care for that is breached and their patient is physically harmed. A reasonably prudent nurse under similar circumstances would have provided care differently. The law establishes the standard of care to protect others against an unreasonably great risk of harm. Negligent acts such as hanging the wrong intravenous solution for a patient or applying a warm compress that causes a burn often results in disciplinary action by the State Board of Nursing. Most lawsuits allege negligence. Malpractice is a type of negligence, but a person being held liable for malpractice must be a professional. So certain criteria are necessary to establish a nursing malpractice. The nurse owed the duty of care to the patient. The nurse did not carry out the breach that duty. The patient was injured as a result of the breach, and damages or remedies are allowed under the state. So that is what the difference is with the malpractice. And with the malpractice, um, uh, that person, just remember that person needs to be a professional, and it could be things like failing to check a patient's identification correctly, uh, you know, different things like that, and then you give somebody the wrong thing. Uh, so you got to make sure that you communicate, with your patient and do the correct thing. And the standard of proof is typically what a reasonably prudent nurse would do under a similar circumstance. Okay, so malpractice is the result of nursing care falling below a standard of care in a malpractice lawsuit. It's typically required that the nurse had a duty of care, that physical harm occurred, and that in that state the award of damages or monetary compensation is allowed. So, during a malpractice suit, a nurse actual conduct is compared with nursing standards of care from the ANA. For example, if a patient is burned from a warm compress application, negligence is determined by reviewing whether the nurse followed the correct procedure for applying the compress. If a procedure was not followed, the policy is reviewed. If there is no policy, this could reflect a systemic problem because the nurse are not providing information regarding current evidence-based knowledge to guide them on how to appropriately apply warm compress. There is a greater possibility that the other patients are at risk for or have already had burns due to erroneous application of warm compresses. The litigation would encompass more than failure to simply follow a procedure. The policies and procedures that guide your practice need to be updated regularly by the nursing department. So that is what, so you get. So usually people do have malpractice insurance, especially um, when they work and they do work on their own. So it's a insurance, a contract between the insurance company and a nurse or employer. Usually, if you work for an agency, a lot of times they kind of cover you up under their malpractice insurance for that particular agency. And then the costs are not very high for insurance. Most people want you to get like 500,000, and it's like $300 a year or something. It's not really that high. But a lot of times, uh, most people are carried by their healthcare agency, and they fall up under their insurance. So you have nurse experts. When a case that involves nursing care is filled, a nursing expert will often testify about the standards of nursing care as applied to the facts of the case. The expert nurse must determine that no conflict of interest exists before accepting the case. So, depositions or interviews in which lawyers can ask questions of others who are under oath, or interviews in which lawyers can ask questions of others who are under oath to provide honest and complete answers. These interviews are transcribed by a court reporter, and then they do a deposition, and it's like also they do always say that ignorance of the law or standards of care is not a defense against malpractice. So always know that as well. So so we talked about that. We talked about the nurse experts. So you want to reduce legal risks in addition to being aware of the actions taken at the organizational level by your employer. It's important that you remain involved in the nursing profession to reduce your personal legal risks as well. Okay. So risk management and performance quality improvement programs help to reduce a nurse's legal risk for malpractice and negligence because they help to identify potential hazards and eliminate them before harm occurs. So it is important to implement actions in your own practice that will help reduce your legal risk, and develop and use clinical judgment to identify patient needs and make sound clinical decisions. Remain aware of current issues and things that are going on in healthcare, and become involved in professional organizations and committees that define the standards of care for nursing practice. So that'll be it. Yeah, that's it.